Starting in 5 seconds. I have repeatedly been impressed during my visits to the Soviet Russia and to the United States by the many things they have in common. I am thinking more about the people than about politics. The people in both countries are in some ways remarkably similar to each other. They are frank and hospitable and are exceedingly friendly. Essentially, I am thinking of one common feature today in the Soviet Russia and in America, namely the concentration of technological and scientific development as a means to progress. The Russians, in spite of their political differences, are full of admiration for the technological civilization which the United States has built up. They want to do even better. Theirs is a competitive approach. It is because of this, I think, that once they get over the present day political difficulties, the people of the Soviet Russia and the United States are likely to come much nearer to each other than possibly other countries might. America, by and large, is a welfare state. There may be odd things here and there which do not fit in with this concept, but it is a welfare state. You have solved your problems of providing the primary necessities of life to the people. We in India have not. Our problems in India are fundamentally concerned with the primary necessity of life. In that sense, our problems are different from yours. Therefore, the pure American approach does not often fit in because you think in terms of an affluent society. For example, you may think in terms of highly mechanized agriculture, but it may not suit India. Not that we are against mechanization, but it may not fit in with the conditions in India. In the Soviet Russia, there has certainly been a very marked and progressive change from the rigid authoritarianism of Stalin's time. We must remember that in the Soviet Russia, at any rate in the greater part of it, they never had anything but some kind of authoritarian government, whether it was the Tsar's government or any other government. From that, they went on to a communist regime which has brought them some advantages, undoubtedly, but at the cost of individual liberty. They do not feel the lack of it very much, but ultimately, everyone feels the lack of individual liberty and lack of individual freedom. Every revolution after a certain period turns down. After the French Revolution and the days of terror, the French people turned down and became a very conservative and respectable people. Surprisingly, the process has taken a longer time in the case of the Soviet Russia, but the process is there. Possibly the period has lengthened because of many factors, including the wars. I once asked a Russian leader who had said something rather nasty about the British people as to why he did so. He had previously told me that he wanted to be friends with America and with England. He had said, "You are friendly with both, help us to be that." I said that I cannot do much, but I will certainly help to the best of my ability. He repeated what he said. Some 2 weeks later, he was traveling about in India and he came back from Burma. In Burma, in answer to a British correspondent who had put some kind of a leading question to him, he had lost his temper and said something nasty about the British people. So I put it to him that you say that you want to be friendly with America and England and want me to help, and yet you say things which must infuriate every Englishman. Surely that is not the way to help that process which you desire. He said that yes. Do you realize that for 30 years or so, whatever the period, we have lived in Russia in a state of siege? We have lived in a state of siege with our enemies surrounding us and trying to put an end to us, crush us. We have fought and survived and we have developed ourselves, but the state of siege has conditioned us. We are suspicious of everybody, especially of these people who have participated in this siege, and if they do anything which we do not like, we retaliate immediately. The reaction is there without even thinking. So you see the result of past conditioning. It is very powerful factor in every nation. Yet you see one gets over it. Take the last war. How did people in America or in England or in many other countries feel about Hitler's Germany and about the Nazis? They felt very angry, no doubt, but today they are friends with the German people, and rightly so. You have got over it. How did you Americans feel about Japan during the war? You were very bitter, and yet you are relatively friendly today. It is extraordinary how these things changes can take place and feel friendly towards each other. Stop. Starting in 5 seconds. Sir, I am grateful to you for the address which you gave us yesterday. It showed how hard the Prime Minister had bargained and tried to get good terms from the six of the European Economic Community. We are grateful to him for what he did. I must, however, confess that the ultimate picture which has emerged is hardly satisfactory. Each group of countries is somewhat differently affected. The Prime Ministers of Canada and New Zealand have stated their views on how the present proposals affect the more developed countries. President Ayub, whose country is faced with problems similar to ours, has stated his views. I largely agree with this general approach to the problem. I shall naturally deal with the problems facing developing countries like India. I should like to make some general remarks. You, Mr. Prime Minister, referred in your opening remarks to the world situation, the present conflict, the two world wars, and the need to prevent a collision between the two great powers. You also referred to Europe's concern with the East West conflict. We are all concerned with it. Every step which we now take must therefore be judged from this point of view, namely whether it reduces tension between the East and the West and whether it decreases the threat of war. We fear that the effect of the present proposals and the UK's entry into the European community might be the reverse and might add to the tension between the East and the West. Some East European countries have claimed that the European Common Market will lead to an extension of the NATO alliance. That may not be wholly correct, but it may well result in the increase of tension between the East and the West. The chances of disarmament would grow less. That would be a terrible loss, for disarmament will lead to greater economic progress than the creation or extension of economic communities. These are considerations which should be borne in mind in the context of the wider world situation. Coming to the present proposals, I should like to remind you, Mr. Prime Minister and other Prime Ministers, that there is need for a new approach of promoting a more healthy relationship between the developed and developing countries. The UN has declared the present decade as the decade of economic development. Declarations have been made in Gate that immediate steps would be taken to fix terminal dates, to relax tariff and other barriers, and expand exports of the developing countries. Even some members of the Six in their agreements with us in 1959 had agreed to practical measures for an increase in our exports, for example, of jute goods and cotton textiles to Germany. It was expected by us that as a result of a growing realization on their part that we could continue to import more and more from them only if we were able to export more and more, we would be able to work out trading arrangements to provide growing outlets for our products on the continent. This has been the general trend and approach. How far does this general approach fit in with the present proposals? I do not see them fitting in. The present proposals are vague and the approach so far made is not satisfactory. Comprehensive trade agreements are a good idea, but in the quest for what has been described as a balance of bargaining positions, the prospects of our being able to negotiate a really worthwhile agreement with the enlarged community seem to us to have been seriously prejudiced. The developing countries are struggling hard to raise the standard of living of their people and the levels of their production. It is impossible for us to import machinery and capital goods necessary for our development plans unless we can increase the level of our exports. We are grateful for the foreign aid, which is largely in the shape of loans and credits. These have to be paid back with interest. We can pay them back only through increasing our exports. There is no other way. We are in the middle of the third 5 year plan. The existence of trade links is important. We are thinking of our fourth and fifth 5 year plans in our prospective planning. We are naturally worried by the adverse effects of these proposals on our plans. The UK's entry into the EEC may well worsen the position not only in relation to our earnings of foreign exchange but in relation to unemployment and might have grave some social consequences from the human point of view. All this does not fit in with an international approach or an approach of gate as it is generally accepted. The accession of the United Kingdom to the EEC means some diminution of our sovereignty. We need not be afraid of that if it leads to a world order. Stop. Starting in 5 seconds. Sir, I think this is a very important amendment to the Constitution that we are considering, and it requires a certain degree of serious attention and serious consideration. I would like to make 5 major points. The first point concerns the federal structure of our Constitution. I remember that it was very wonderful and very nice to hear my old friend, colleague, somebody with whom I had interacted for more than 2 decades, and somebody with whom I had many a contentious argument, and particularly on this issue as well, and it was wonderful to hear him once again. So, welcome back, and thank you very much for what you have said. But I would have also like to add as a compliment and not to be considered as an offense that he sounds much better from the other side of the house instead of this side of the house. So, thank you very much for that. Sir, this is an issue on which we have a very serious point. Article 1 of the Constitution of India says India, that is Bharat, is a union of states. Without the states, there is no India, and the federal structure of our Constitution springs from that concept, and therefore the entire structure, the federal structure, and the rights of the states is something that is absolutely fundamental to the Indian Constitution. It is that Constitution because of which all of us are here and are discussing, and therefore this issue of journal goods tax services were not included at that point of time when the Constitution was being debated. What is being talked about was taxed on goods. This is not a new concept that has come up now. It has been going on in our country at least since the Constituent Assembly debates. The question was whether the states should have the right to have a sales tax. Let me quote Dr. Ambedkar on this issue. In the Constituent Assembly debates, what does he say? I quote, "It seems to me that if we permit the sales tax to be levied by the provinces, then the provinces must be free to adjust the rate of the sales tax to the changing situation of the province, and therefore a ceiling from the center would be great handicap in the working of the sales tax as such." He continues, I quote, "There are a large number of resources on which the provinces depend has been concentrated in the central list. It is desirable at least to leave one important source of revenue with the provinces. Therefore, I think that the proposal to leave the sales tax in the hands of the provinces from that point of view is a very justifiable thing. This issue has been under debate since then. We introduced the VAT in our wisdom. Much of that has been encroached upon. Now the GST bringing the services also into its ambit along with the goods will virtually take away this right. Now the state governments, which were called the provinces, then not having any right to raise resources from whatever they would consider they are elected, they consider as important for the welfare of the people in those states, that will now be prohibited. How are you going to address this issue? I myself told this to the finance minister, and he said that at the time when the GST bill comes, this should be addressed, leaving some flexibility to the states. I will tell you why today. You have the Kerala government from where you come, sir. The state has imposed a tax called the health tax. It is on your fast food and all these sorts of food items that increase obesity. It is a very noble thought. It has been welcomed internationally, but such rights will not exist after we enact this amendment and the bill subsequently. Take the case of the state where I come from. A tax has been imposed, a surcharge on cigarettes has been imposed to raise revenue to pay for the victims of the Shadra scam. People are being asked to pay for the victims of the Sharda scam. Whatever be that issue, that is a separate issue. Such rights do not exist in case of national calamities. Are we to reduce the elected state governments, wherefrom the people of these states come to the center with a begging bowl, saying that declare so and so issue as a national disaster and give us certain amount of money? What will be the legitimate rights of the states? And we are the Council of States in this august house. How do we protect that right? That is an important point that needs to be considered, as therefore I would request the finance minister, when he replies today, to ensure that there is a flexibility of this nature whereby the states do not end up actually coming with a begging bowl to the center in the following years later. Stop. Starting in 5 seconds. It is gratifying to notice that the Indore bar has grown over the decades and produced eminent lawyers and judges whose contribution to the legal field has been significant. In the mighty freedom struggle that took place prior to independence, the role played by the bar and its leaders in this country is memorable. Mahatma Gandhi, who held the torch of freedom struggle with unparalleled courage and dedication, was himself a lawyer. So was the case with other eminent leaders of the freedom movement like Jawaharlal Nehru, Sardar Patel, and innumerable other leaders. Legal profession in any politically organized community has got a unique place among intellectual professions. In our constitution, we have adopted democracy as a way of life based on the rule of law and supported by the triple arc of liberty, equality, and justice. In the preamble to our Constitution, we have proclaimed these as basic guarantees under our political system. As you are aware, for a democratic system to function effectively, not only should there be meaningful checks and balances of various organs, but they must all be coordinated for ensuring the progress of a country. While the legislature, as a democratically elected body, is entrusted with all the tasks of deliberation and making law, the judiciary, with all the independence at its command, is entrusted with the supreme responsibility to administer justice, and that must be done according to law. Laws are made in the legislature not for adorning the statute books but to serve the purpose of socio-economic change. They are born in response to demands arising from the unsatisfied, nevertheless legitimate human desires and ambitions. Indian philosophers consider the Dharma, which embodies different laws and duties, as supreme. The Upanishads, which echo our philosophy, observe law is the king of kings, far more powerful than they. There is nothing higher than law, and by its province as by that of the highest monarch in heaven, the weal shall prevail over the strong, and justice will triumph. Neither the Constitution nor laws created under the Constitution are ends in themselves. They are created for the purpose of meeting the challenges the society faces in social, economic, and political spheres as well. From time to time, democracy is always entitled to lean on the power of the Constitution and law for the purpose of bringing about the socio-economic reforms for its poor people, the object being attainment of a welfare state. Even though we have guaranteed freedom of life, liberty, expression, and belief inter alia under our Constitution, we have yet to guarantee freedom to the teeming millions from want and ignorance. In this country, out of over 60 crore people, 80% live in the villages. It is the responsibility of those who consider themselves as the cream of the society to endeavor to ensure that not only the basic human rights of unfortunate millions are protected, preserved, and defended, but also endeavor to improve their economic conditions and life. We have to do everything to assure them that they need not go to sleep with empty stomachs in the night, but they can also wake up in the morning with the prospect of having a happy day for them and their families. It is in this delicate phenomenon of bringing about a socio-economic transformation peacefully by the force of laws derived from the Constitution. We desire that all intellectuals should play a very important role. The role of lawyers in meeting the challenges a nation faces from time to time has been ever unique. The legal profession is considered noble not only because the administration of justice is assisted adequately, but because the profession upholds the right of dissent and also fights for the rights of those who are unjustly deprived. In the early days of the Greek and Roman empires, the functions of a state were exclusively confined to ensure security of the state and to administer justice. Societies from time immemorial have been conflict ridden. As long as basic instincts in man continue to prevail over his actions, conflicts in one form or the other are inevitable. A state which fails to resolve conflicts through the instruments of law will no more enjoy the confidence of its subjects. It is in this context that members of the legal profession can help the courts in administering justice well and effectively. Justice should not be delayed, nor should justice be hurried. To the age old adage, justice delayed is justice denied, it may be appropriate to add justice hurried is justice buried. When justice is to be done between two conflicting groups or individuals, all aspects are to be carefully considered and weighed, and adequate opportunity of being heard will have to be given before delivering a verdict, because any verdict may affect the future generation as well. This is where the legal profession has a very delicate and vital role to play in protesting against the cruelty and crimes committed against human rights. It is essential to provide machinery to judge and punish them also. Stop. Starting in 5 seconds. Tomorrow we will celebrate the Republic Day. On this auspicious occasion, I am happy to greet you all, my fellow citizens at home and abroad, and convey to you my good wishes. This is no doubt a joyous occasion, and we celebrate it with all enthusiasm. But this is also an occasion for calm introspection about where we stand and in what direction we are going. A few years back, our country was suffering from a deficit in food grains, and some people abroad had written us off as a country which could not be saved. In their view, our agriculture had no future and we would be exposed to recurring famines. These prophets of gloom had reckoned without our untiring Kisan, and they have been proved false. This country, which was producing 5 crore tons of food grains in 1950, has now reached a level of over 20 crore tons despite of floods and other natural calamities in several parts of the country. The credit for this goes to the Kisans, the vast majority of whom are small and marginal farmers. The developmental efforts over the last 30 years, which have been channelized by successive 5-year plans, have resulted in the execution of many major, medium, and minor irrigation projects all over the country. The assured water supply from these projects, as well as production of fertilizers, pesticides, and high yielding strains, have all aided the Kisan in ushering in an era of plenty. Because of the record output of food grains and industrial raw materials, we have been able to achieve a measure of price stability and contain inflation. Food sufficiency is among the major factors that have helped the country to sustain and strengthen its political and economic independence. We cannot, however, afford to be complacent. In the coming years, we will have to place agriculture on a sounder and more viable base. We will have to assure fair prices for the farmers' produce and reduce the cost of inputs that will encourage the Kisan to work harder and show better results. There has to be an intensive study of the agroecology of every area, and we must build up self reliance of each area in order to ensure the full development of its potential. If farmers, scientists, extension workers, developmental administrators, mass media agencies, and above all, our political leaders will all work together, we can soon regain the old image of our as a land full of milk and honey. While this achievement is certainly within our reach, a radical change in the entire value system of our urban societies is essential for attaining this goal. The brain drain and the depletion of resources from the village to the city must not only be stopped but must be reversed. The imperative need is for a happy combination of brain and brawn for achieving the rural prosperity. Those living in villages and our scientists and technologists who choose to work in villages must be provided with adequate facilities. The basic minimum needs of the rural people must be fulfilled without further delay. In the welter of demands and agitations by the urban pressure groups for an ever increasing share in the national cake, the needs of the poor farmer, the real producer of wealth in our country, are apt to be overlooked. Let us not forget that India will prosper only if the tiller of the soil lives and prospers. Our hard-working peasantry have proved time and again that they are ready to adopt new technology provided they are helped to do so. It is now the responsibility of every citizen in this country to ensure that our farmers are able to produce more food from less land. This presupposed considerable attention in safeguarding our basic agricultural assets like soil, water, flora, and fauna so that productivity can be improved without harming the long term production potential of soil and water. I have had occasion to fly over the Himalayas in recent months, and I was shocked to see the extent of deforestation that has taken place. What was once all greenery has been reduced to barren rocks. Such denudation and the resultant soil erosion pose a grave danger to our future. Floods and droughts are caused by thoughtless destruction of forest. We should ensure that in our zeal to bring more land under the plough, we do not disturb the delicate balance of nature. We need to create new forest belts to be maintained in perpetuity. I am happy that the state governments are now imposing restrictions on the felling of trees and preventing further denudation of forest areas. But this is largely a matter for community involvement and initiative, and I hope our people, particularly in the rural areas, will take up this work in right earnest. If today many people still go without enough food, it is not because of lack of food but rather because of lack of purchasing power. Hence, our agricultural plans will have to aim at generating more and more employment in the rural areas in addition to providing food for our growing population. Stop. Starting in 5 seconds. The Rajasthan State Road Transport Corporation has filed the above appeal aggrieved by the judgment of the Rajasthan High Court of Judicature Jaipur bench by which regulation 4(3) of the Rajasthan State Road Transport Corporation Compassionate Appointment Regulations 2010 has been declared as violative of Article 14 of the Constitution of India. The respondent's father, Mohammad Shahid, who was working as a helper in the appellant corporation, died in a motor accident. He was traveling in a bus of the appellant corporation which collided with another bus. A claim was made by the respondent before the Motor Accident Claim Tribunal Tonk under Section 166 and of the Motor Vehicles Act 1988. An amount of rupees 135 lakhs was claimed, but the tribunal awarded a compensation of rupees 22 lakhs. The respondent made a representation to the chief manager of the appellant corporation seeking compassionate appointment. The request for compassionate appointment was rejected on the ground that the respondent was not entitled in light of Regulation 4(3) of the regulations. Dissatisfied with the rejection of the request for compassionate appointment, the respondent filed a writ petition in the High Court challenging the constitutionality of Regulation 4(3). The High Court allowed the writ petition by a judgment on the ground that regulation 4 under bracket 3 of the regulations is discriminatory and violative of Article 14 of the Constitution. The High Court held that the object of compassionate appointment is to mitigate the hardship of the family members of the breadwinner, and for that reason, compassionate appointment should be provided to the family in distress. According to Regulation 4 bracket 3 of the regulations, claim for both compassionate appointment and compensation under the Act cannot be made against the corporation in case of death of an employee while traveling in the vehicle of the appellant corporation. Regulation 4 bracket 3 was found to be discriminatory because compassionate appointment can be provided to an employee who dies in an accident while traveling in a vehicle not belonging to the corporation, though he had claimed compensation either from the owner of the vehicle or the insurance company under the Act. Before proceeding further, it is relevant to take note of Regulation 4 bracket 3 of the regulations, which allows computation on account of injury or death to the person while performing official duty. This is the case for that period. On the occasion of death of an employee of the corporation while performing his duty, or a vehicular death by the vehicle belonging to the corporation, if the legal representatives of the deceased employee seeks compensation from the corporation by filing a claim petition before the accident tribunal and the same is awarded or the matter remains pending before the tribunal, in such a case the legal representatives of the deceased employee shall have no right to seek appointment on compassionate ground if compensation is awarded or the matter remains pending before the tribunal. If on the death of an employee of the corporation, his legal representative at the time of compassionate appointment files an application for the same in the prescribed format, then the application for appointment on compassionate ground has to be supplemented with an affidavit on a non-judicial stamp paper of rupees 10 by the legal representative that no claim petition against the corporation has been filed before any competent court, and also that no such claim shall be filed in the future, and if in future, even if any of the legal representatives files a claim petition before MACT, then the employer shall have right to cancel my appointment without any notice, and that I won't file any case against such dismissal before any competent court. According to the said regulation, the death of an employee of the corporation while traveling in a vehicle belonging to the appellant corporation cannot give rise to compensation under the Act, as well as a claim for compassionate appointment in the appellant corporation. The question that arises for our consideration is whether the High Court was right in holding that Regulation 4 bracket 3 is discriminatory and violative of Article 14 of the Constitution. The reason given by the High Court to hold it unconstitutional is that whereas the dependents of the employee who died in an accident while on a vehicle owned by the appellant corporation are not entitled for compassionate appointment after claiming compensation under act. The dependent of an employee who died in an accident while traveling in a vehicle not owned by the appellant corporation are entitled to get compensation under the act against the owner of the vehicle or the insurance company as the case may be, as well as a right to claim compassionate appointment. The High Court was of the opinion that the dependents of employees of the corporation who died due to an accident while traveling in a vehicle of the corporation cannot be treated differently from dependents of employees who died in an accident while traveling in a corporation vehicle. Stop. Starting in 5 seconds. Making the above submissions, it is prayed to allow the present appeal and direct the respondents to appropriate the payment of rupees 1.25 crore towards settlement dues under the scheme 2019 and that discharge certificate be issued to the appellant accordingly. While opposing the present appeal, learned ASG, appearing on behalf of the Union of India, has vehemently submitted that in the facts and circumstances of the case, no error has been committed by the Honorable High Court in dismissing the writ petition and refusing to direct the respondents to accept the payment towards the settlement dues under the scheme 2019. It is submitted that admittedly the scheme was valid up to 30th June 2020 and the last date for the payment of settlement amount under the scheme 2019 was 30 June 2020. That thereafter the scheme was closed and even the designated committee were also dissolved, and therefore, as rightly observed by the Honorable High Court, the Honorable High Court has no jurisdiction to extend the scheme. It is submitted that if the scheme is extended, it would create many complications. It is further submitted that in the present case, admittedly, no payment was made of settlement amount under the scheme prior to 30 June 2020, and therefore the prayer of the original petitioner to extend the time limit to make the payment of settlement amount under the scheme 2019 was rightly rejected by the commissioner, and the same has rightly not been interfered with by the Honorable High Court. Making above submissions, it is prayed to dismiss the present appeal. We have heard the learned counsel appearing for the respective parties at length. At the outset, it is required to be noted, and it is not in dispute, that the appellant is entitled to the benefit of the settlement under the scheme 2019. The scheme 2019 came to be introduced on 1st September 2019, and the last date for making the application under the scheme was 30th December 2019, and in fact the appellant submitted the application in form number 1 on before the last date specified for making an application under the scheme. After the form number 1 is processed, the designated committee was to scrutinize the same and issue the final form number 3 determining the settlement. The final determination, form number 3, that the appellant was issued the form number 3 on 25th February 2020 and was required to pay the settlement dues on or before 25th March 2020. However, in view of the COVID 19 pandemic, the government extended the time up to 30th June 2020. Therefore, the appellant was required to deposit the settlement dues on or before 30 June 2020. However, even before the scheme 2019 came to be introduced, the appellant was subjected to proceedings under the IBC, which commenced when the NCLT admitted the application under Section 7 of the IBC. Thus, the moratorium under the IBC commenced on 11 September 2018. The COC approved the resolution plan on 4th June 2019 and the same came to be approved by the NCLT by order. Therefore, the moratorium under the IBC continued up to 24th July 2020. Under the provisions of the IBC, no payment could have been made during the period of moratorium. Therefore, the appellant was statutorily restrained from making any payment. There was statutory disability on the part of the appellant in making the payment during the moratorium. If the appellant had made any payment during the period of moratorium, the appellant would have committed breach of the provisions of the IBC. Therefore, it was possible for the appellant to make any payment during the period of moratorium. Immediately on the moratorium coming to an end, the appellant approached the authority requesting them to accept the settlement amount under the scheme 2019 as per the form number 3. Such request has been rejected by the Commissioner. On the rejection has been confirmed by the High Court. Therefore, the sought question which is posed for consideration before this court is whether, when it was impossible for the appellant to deposit the settlement amount in view of the bar and the restrictions under the IBC, the appellant can be punished for no fault of the appellant. In a given case, can the applicant be made to suffer for no fault of its own and be rendered remediless and denied the benefit, though it was impossible for the appellant to carry out certain acts, namely to deposit the settlement amount during the moratorium. As per the settled position of law, no party shall be left remediless, and whatever the grievance the parties had raised before the court of law has to be examined on its own merits. As observed and held by this court, no law would compel a person to do the impossible. Stop. Starting in 5 seconds. learned counsel appearing on behalf of the state while opposing the present appeal has vehemently submitted that in the present case the dead body was exhumed from the place shown and identified by A1. It is submitted that the place of burial shown by A1 and the identification of the body by him has been duly proved by the prosecution. The evidence of anthropology of expert is accepted. It is submitted that even the stolen car was also recovered on the basis of disclosure statement made by A1. It is submitted that engine and gearbox were found to be in custody of PW17 on the basis of disclosure statement made by A1. It is submitted that PW17 has deposed that some parts were sold by A1. It is submitted that aforesaid crucial circumstances have not at all been explained by the accused in his further statement under section 313 CRPC. It is submitted that deposition of DW1 has been rejected by the courts. It is submitted that therefore no error has been committed by the courts below in convicting the accused for the offense punishable under section 302 and other offense of IPC. Making the above submissions, it is prayed to dismiss the present appeal. We have heard learned counsel appearing on behalf of accused as well as the state. We have gone through the findings recorded by the learned trial court as well as the High Court while holding the appellant accused number 1 guilty for the offense punishable under sections 302 and 201 of IPC. It is the case on behalf of the appellant accused number 1 that he has been convicted on the confessional statement and therefore in case of circumstantial evidence and unless and until the complete chain of events were proved and established, he could not have been convicted on confessional statement. However, from the judgment and order passed by the learned trial court as well as the High Court, it cannot be said that the appellant has been convicted on the basis of confessional statement. In the present case, there is no confession by the accused that he committed the offense, which has been but relied upon by the court. The so-called communication by the accused is as such not believed by the court. However, at the same time, it can be seen that the communication or letter received by police on 30 December 2007 was the cause for reopening of the case, as early the case was closed 4th February 2007 as untraceable. That thereafter the actual investigation begun by PW30. That thereafter during investigation A1 disclosed the place where he had buried the dead body of the deceased. The dead body was exhumed from the place identified by A1. Thus, it was a case of recovery of the dead body at the instance of the accused from the place which was disclosed by the accused, who can be said to be in exclusive knowledge of the place where the dead body was buried, that thereafter the superimposition test was conducted and the DNA examination was conducted on the bones and the skull, and it was proved that the dead body was that of the deceased. This is the first strong circumstance against the appellant A1 which has led to his conviction, that thereafter even the car which was driven by the deceased at the relevant time was recovered from PW16, which was at the instance of the accused himself, that there is a recovery of car driven by the deceased from the place and the person disclosed by the accused number 1 appellant. The prosecution has successfully proved the same by examining PW16, a person to whom the stolen car was sold by the appellant accused number 1. This is the second strong circumstance against the appellant accused number 1, that thereafter the prosecution has been successful in proving that the engine and gearbox which were sold by the appellant accused number 1 was recovered from PW17. The engine and gearbox of the stolen car were found from the custody of PW17 on the disclosure statement made by A1. Though PW17 has turned hostile, however, at the same time, the recovery of engine and gearbox from PW17, which were recovered on the disclosure statement made by A1, has been established and proved by the prosecution by examining police witness PW30. We see no reason to disbelieve PW30 on the aforesaid. This is another circumstance against the appellant accused number 1. Thus, on the basis of the aforesaid strong circumstances, when the learned trial court as well as the High Court has convicted the accused with the same in exercise of powers under Article 136 of the Constitution of India. Stop.